I'm a doctor. I'm performing surgery. And I screw up. And I know that I've made a mistake. I try to cover it up. I try to make it all better. But I chopped off the wrong leg. That's a really overt one. Or I put a pin in a hip, and it was defective. Or I did it wrong. I committed an act of negligence. And I knew it when I did it. But I sewed the guy up and I sent him home. Does a claim exist? Under the Uniform Fraudulent Conveyance Act, and the general rule is yes, because you were aware that you did something wrong, even if the liability had not been asserted yet. So it may include contingent claims, disputed claims. If there's some right to payment from you, then a claim exists. You've got to be careful. So anyone with a claim is a potential creditor, and if you make a transfer after that claim exists, it may be too late. This is where I've seen a lot of financial advisors get in trouble. So contact a lawyer if you ever have a client ask you this question, because it really depends on the state and the facts. And there is no black and white in this. Suspect transactions. Well, courts always look at transactions, transfers made to insiders, so relatives. So you take it, the question I always get is, should I transfer the business to my wife? Okay, you can transfer it to your wife. What if you get divorced? Duh. But if you do transfer the asset before the claim arises, it may be protected from your creditors. Insolvent. If you are insolvent at the time of the transfer, or the transfer will make you insolvent after the transfer, then that can cause the transaction to be unwound by a court. Okay? And then if there's a transfer without value, so I gift the asset. Claim, I know the claim is coming, or there could be a claim against me, or there is a claim against me, and I make a transfer to my son of my property in Herndon. Can they get that property away from my son, even though I've clearly deeded it to them? I gifted it to my son or my kids, or even to an irrevocable trust that's out of my control? Yes, courts can unwind these transactions, and they often do.
Including to a spouse.
Particularly to a spouse. That's the easiest to unwind, right? Because spouse is considered very close in terms of relationship, about as close as it gets. The question is, when did the claim arise? So if there was a claim at the time of the transfer, it can be unwound. And the suspect transactions, the timing of the transaction and who it is to, is really focused here. So I've made a transfer to my spouse. Well, when did you make it? Did you make it before you conducted the surgery? Because the surgery is the claim that we're talking about in this particular case. Or before you rendered advice on the lease as an attorney and you gave bad advice? When did the act occur and when did the transfer take place? And then who did the transfer take place with? So if you sold the property to an unrelated third party for fair market value, then that is less suspect than these types of transactions and less likely to get unwound. So when it is too late is really probably one of the most important discussions that you'll have with a client. You're not advising them as lawyers. You're going to turn them over to a lawyer, but you're going to gather some facts to talk to the lawyer maybe on their behalf, because they may not be able to do it because they may be too emotionally involved or whatever. You can help them with this.
What type of lawyer specializes?
Estate planning lawyers do a lot of asset protection. We have a bankruptcy group here. We have 3 lawyers. All they do is bankruptcy litigation. We usually represent the creditors, not the debtors. So, because it's more lucrative, but there are lawyers that are Chapter 7, Chapter 13 individual bankruptcy experts. we'll refer clients to those. We don't have very many clients who go through that, but to the extent somebody comes to us, you come to us and say, one of our client's kids did this, and there's a huge claim that's potentially pending against them. We need some counseling on what to do about bankruptcy. Should we go bankrupt? And what is subject to the claims of the creditors? And how do we protect the assets? And that's really the bankruptcy lawyers we bring in, people who are experts in debtor-creditor law. In terms of how to protect it, the estate planners do a lot of that. So we work with our bankruptcy brethren and sisters who do that type of work. Work very closely with them.
Can you just hold the second point again, the insolvent debtors? You said
Yeah.
if you transfer an asset and then you become insolvent after you transfer?
So badges, these are called badges of fraud under the Uniform Fraudulent Conveyance Act. And the question is, what do you mean by transfers that cause you to become insolvent, or if you are insolvent at the time of transfer? If a claim is there, there's a creditor after you, and you own $1 million house, but that's really all you've got. You've got equity in that house, and you transfer that to your sister. You just deed it to her. You've done it for no value. And this creditor has a claim that might be $2 million because of an automobile accident, and there's not enough automobile insurance to cover you. So your liability is greater than your asset, your net worth. At that point, you're insolvent already. But let's say the liability was $500,000, and your asset was $1 million. But you transfer the $1 million asset to your sister. Now you've got a liability of $500 and assets of $0. So you made the transfer at a time when you were solvent, but it made you insolvent following the transfer. That's a badge of fraud. And a court will look at that and potentially unwind the transaction. Good questions. Any other questions on this? This is interesting stuff. It's applicable to all of us in our lives at one point or another. We think about it. And our clients, we always think about this. Now, exemptions. There are certain assets that are exempt from the claims of creditors, even in bankruptcy. You've heard about the homestead exemption. It's pretty big in Florida. In Virginia, it's next to nothing. In Maryland, it's also very limited. So it's not something that we rely on in advising our clients, hey, your home is, don't worry about it, it's protected. There's another way to protect your home from your individual creditors. We'll talk about that. Qualified plans and IRAs. This has become a complex area because there was a Supreme Court case that came down about 2 years ago called Clark versus Ramekin, and it ruled, surprisingly, that certain IRAs and certain retirement assets are not protected in bankruptcy, when we always thought that the general rule of law was that all qualified plans and IRAs up to a certain limit are protected, even in bankruptcy, from creditors. And this Clark versus Ramekin case basically said, look, if you inherit a retirement plan from your dad or your mom or a sister or a brother, you didn't work to create that retirement asset, and it's really not a retirement asset. It's converted into something else after the death of the person who created that asset. There's an exception in the Supreme Court ruling that leaves open the question of whether spouses can inherit and roll over IRAs, and we believe they can, but it's still a big issue. So, inherited versus not inherited, we believe that if a spouse takes a deceased spouse's IRA and rolls it over into their own inherited IRA, it's protected from creditors. Qualified plans are unlimited in their protection. IRAs, $1,283,025 this year. It went up in April. They set it every 3 years. So $1,283,000 is the limit on protection in bankruptcy. But what if I've got 3 IRA accounts that total $6 million, or $3 million, but each is $1 million each? They aggregate the total. So it's a maximum liability protection.
What if it was a rollover from a qualified plan?
So again, the same issue. Who can roll it over? A spouse can roll it over, right? Spouses will retain that protection even if it's in an IRA.
But what if you left a company, you rolled your $1 million 401k over?
You've lost the unlimited protection. Which, raises questions. Should I leave it in the company's 401k? Should I leave it in the profit sharing plan? Most companies don't want you to do that anyway.
So that means that the new DOL rule in April next year,
Which DOL rule?
so
The fiduciary rule?
yeah, future rule, if we recommend that somebody moves the company and goes from a 401k into our IRA, then we are at risk.
You're not at risk. What you need to do is educate. You have to be aware of the rule and you have to be able to educate. And if you educate, they're taking the risk. So you just want to make sure it's in writing so that your oral education is not construed as never having been made. These are great questions, by the way.
Yeah, I don't know who else, but I know UBS, we can't reduce solicit the rollover. There's a whole Indian homework that needs to be done as far as why you think you're not just going to put a wrap around the same thing you have in there. It should be hard to do. Or it's got to be, totally unsolicited rollover. But then I see Fidelity commercials that are like, oh, you got rollover, put it over.
Well, let me repeat it for the camera. At the big wirehouses, big investment companies, they're requiring very specific criteria be met before you can roll over from a qualified plan into an IRA. And I think that's reflective of the current environment in dealing with 401ks as investment advisors. You are now subject to this fiduciary rule. And as a fiduciary, you have to understand that you're not just limited to what you advise in terms of your investments, but it's also all aspects of managing the retirement account. As a fiduciary, you have to educate them, and therefore you must be educated. And if you don't know these rules, or if you don't know about what a fiduciary means, then you shouldn't be handling 401ks, which is why a lot of people are getting out of the business. They have departments, compliance departments, who built rules and regulations around the new rules and regulations to advise their advisors on what to do. And you should follow those rules carefully. If you're an independent financial advisor and you're managing 401ks, you'd better educate yourselves or hire somebody to educate you on how to comply with these new rules, the new DOL rules, which, by the way, the Securities and Exchange Commission wants to expand to apply across the board to all registered investment advisors. And it won't be long before that may happen. And that imposes a much stricter, much greater scrutiny on your activities as an investment advisor and what you do and what you tell your clients.